Hi, my name is Michael Burgis, and I'm the managing attorney of MB&A. My firm specializes in California workers' compensation, employment law, catastrophic civil liability, and just catastrophic injuries in general. I wanted to make this video to educate some of my viewers on some important case law. Now, I've also shot a video regarding what's called Benson apportionment, or Benson versus Workers' Comp Appeal Board. Link below. I recommend that you watch that video prior to watching this video, as you may not understand this video in totality without watching that. Now, Benson apportionment, as described in my prior video, is apportionment amongst multiple dates of injury. Breaking disability down between one injury and multiple injuries drastically decreases the monetary compensation to the injured worker. So, finding an exception or arguing that those injuries are quote-unquote inextricably intertwined to get a joint award is a very big issue. It should absolutely be done when advocating for an injured worker who has multiple injuries or disability apportioned to multiple industrial injuries. Now, I want to talk to you about a noteworthy panel decision called Jerry Dileva versus NORTHROP GRUMMAN. This is a huge case for injured workers. It's citable authority. It's not binding because it's not an in-bank decision or a Court of Appeals or Supreme Court decision, but it is a very good case. It's citable. You can cite to this and argue this. It's persuasive, and the truth is, it's the law. It's accurate, okay? Now, I know this case better than anybody because I was the trial attorney on this case.
My name is Jerry Dileva. My case involved multiple injuries and multiple dates, so it seemed very complicated and confusing. I feel that Michael is one of the best. My case, it became a law, and to be honest with you, I was very hurt, so bad that I was wondering, how can I help others? That's my whole life, helping others. And when I learned that my case became law for the state of California, which is DiLeva versus NORTHROP GRUMMAN Corporation, I was excited. If you're really serious in a workman's comp case, what can I say? Michael Burgis is the guy. His staff will treat you right, you'll go in the right direction, and I guarantee you will win.
Jerry Dileva is someone who I just consider a very good friend now, an amazing human being, and I'm very glad that his case is essentially legacy for him. It's a legacy that is helping injured workers throughout the state. And I hope, Mr. Dileva, if you're watching this, I'm glad that it was you on this case, and I'm glad that we got to team up and hopefully accomplish some substantial justice for people who truly deserve it. But here's the holding of Jerry Dileva. If there are multiple doctors and multiple consulting physicians, let's say you have an orthopedist, a psychiatrist, an internist, a neurologist, a rheumatologist, can be any doctor in any field. When you have multiple doctors and subspecialties, let's say hypothetically that the orthopedist is able to partition the orthopedic disability amongst the two injuries. And in Mr. Dileva's case, there was 3 injuries. So let's say that, and use Mr. Dileva's case, but 2 specific injuries and an overlapping cumulative trauma. Now, we had an orthopedic agreed medical examiner who found considerable disability for Mr. Dileva because he was very much injured. And this doctor apportioned it 50% to this injury and 25 to this and 25 to that. First off, I don't think that was substantial medical evidence, but let's assume as a hypothetical that was accurate and substantial. And a trial judge confirmed that the orthopedic injuries were properly apportioned 50%, 25, 25. Now, in this case, I also had an internist and a psychologist indicating that yes, the internal medicine and the psychological respective disability was a clear compensable consequence of the orthopedic injuries. And the orthopedic injuries were industrial, therefore, the internal and psych injuries are industrial. The issue here, though, is those doctors need to separately comment and decide whether they can address and find apportionment amongst those multiple dates of injury. Now, Labor Code 4063 on apportionment and Escobedo and the seminal case law discussing apportionment and Benson apportionment all make it very clear that a doctor needs to discuss apportionment. If they don't discuss apportionment, the medical report doesn't constitute substantial medical evidence. That doesn't mean that they have to find apportionment. Now, defense attorney after defense attorney, day in and day out, I litigate against these guys, and they are the opinion they have to find apportionment, and they have to articulate what percentage is attributed amongst the multiple dates of injury. That is wrong. They need to address apportionment. But if the doctor can't find or indicates that they can't comment on apportionment or they can't address apportionment, then the labor code says they shall consult with another physician to see if they can do it. Okay? But taking it a step further, and what happened in Mr. Dileva's case is those doctors did address apportionment. They opined that the apportionment amongst the multiple dates of injury based upon their subspecialty, internal medicine and psychiatry, they found it was quote-unquote inextricably intertwined. That is, that they couldn't articulate what the exact percentage it was or what their best estimate was to a reasonable degree of medical probability because it was inextricably intertwined. So I argued that if one doctor finds it inextricably intertwined, then essentially the applicant is entitled to unapportioned award for everything, because if you do the math, it just doesn't work. You can't just guess at it. And if one doctor, I don't care if you have 10 agreed medical examiners and 9 out of 10 do a perfect job, break it all down. If one says it's inextricably intertwined and they explain how and why, and that report is substantial, my argument was everything's unapportioned. You get one award, period. Now, this is huge for injured workers. I went to trial and I made these arguments. Multiple briefing, pre-trial briefs, post-trial briefs, and ultimately we won. And we won, and the court basically upheld my legal arguments. The court found that if one of the doctors found it inextricably intertwined, my client is entitled to unapportioned award. Of course, the defendants appealed this. It went up to the workers' comp appellate level, and this was a very big case. And so the appellate level took the petition for reconsideration under advisement. They put a stay on the case, and for about 8 months, there was supplemental briefing back and forth from the Court of Appeals. Ultimately, the Court of Appeals came down and confirmed the trial court's decision. The trial court was a very smart judge, Honorable Judge Pollack, in the Van Nuys Workers' Comp Appeal Board. And the Court of Appeal, the Workers' Comp appellate level, confirmed the holding. And now this is a case that confirms that analysis, that if one physician finds it inextricably intertwined, the whole case is inextricably intertwined. Now, this is very, very important. The impacts for injured workers are so far-fetched and widespread that I'm very grateful to be a part of this case. And there's a whole bunch of cases that have come out subsequent to that, which I'm going to address in some later videos here. But it is an amazing case for injured workers. It's an amazing case for Mr. Dileva, and I'm glad to be a part of it. And I hope this video was helpful. I hope the viewers got a good education on apportionment, Benson apportionment, and an amazing case called Jerry Dileva versus NORTHROP Grumman. Ladies and gentlemen, if you're watching this, you found it helpful, you have questions, feel free, give me a call. Believe me, we have the answers and we're standing by. Thank you.